Good morning. Are you Jacordi and Guillory?
Yes, ma'am.
And Mr. Guillory has two cases. 23 DCCR 1225 is a motion to revoke probation. Underlying offense is evading arrest or detention with the use of a vehicle. And then we've got 26 DCCR 0631, a new offense of evading arrest or detention with the use of a vehicle. And what is the announcement?
Your Honor, I've reviewed the discovery in this case and discussed it with Mr. Guillory. He's advised that he did not commit the new offense, although the state's conveyed what I consider to be a reasonable offer to dispose of the NTRP in the new case. Since Mr. Guillory is maintaining that he's innocent of the new charge, I have to set it for him.
So I would,
Absolutely not true.
so we want to go through the motion then and go forward on that motion instead of the, let me get that pulled up. And are there any videos or anything that you need some time to watch?
No, I don't think from reading the file, there were some videos that identify the defendant. Or actually identify the person operating the motor vehicle.
Oh, okay. All right. Give me just a second to get that pulled up.
I do have some media on that, Judge, and I'll make sure that Mr. Kimler, if he indicates to the court that he is retained on that case, I will make sure he has access to discovery and I'll make a copy of that.
I've got them on both cases.
Okay.
So if you'll make that request, Mr. Kimler, it sounds like there may be something that,
And also, Judge, at the appropriate time, if I might just ask the court some questions regarding the bond issues, I'd appreciate that.
Mr. Guillory, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down, and will he waive the formal reading of the motion?
Well,
All right, Mr. Guillory, in clause number 23, DCCR 1225, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct?
yes.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest or detention with the use of a vehicle, February 27th of 2026. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
Not true, because
It's okay. I'll get the explanations later. I just need to know true or not true.
yes, ma'am.
Count 3 alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, February 7th of 2026. And is that true or not true? Count 4 alleges that you failed to provide and maintain an accurate residence address with probation officer. It says you reported your address at 2218 Rush Street, but identified your address at 2450 West Lucas to the Beaumont Police. Is that true or not true?
That's not true because I had to change.
All right. Did you tell probation?
Yes, ma'am.
Okay. Count 5 alleges that you failed to provide documentation verifying the source and amount of your income, 2025 tax returns, etc. Is that true or not true?
That's true.
Count 6 alleges that you failed to provide verification of performing community service hours as required. Is that true or not true?
Not true.
Count 7 alleges that you were at a location other than your residence at approximately 11:20 p.m. on February 27th of 2026 in violation of your curfew. Is that true or not true?
Was bad.
February 27th of 2026.
It's not true.
Not true.
Okay. Count 8 alleges that you are behind in your court assessed fees as of April 20th of 2026 in the amount of $1,812. Is that true or not true? All right. Did you enter your pleas of true to counts 3, 5, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find that you entered your pleas of true to counts 3, 5, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke the probation, but I'm not going to do that. I'm going to reset the case for a hearing. And any discovery or any issues with regard to that new case get taken care of before then. And Ms. Malfino, do you anticipate that being, I guess, just one officer?
One officer and Miss Lopez.
All right, so we can just do it at 11, don't y'all think?
Yes.
No, just on a regular court date, but at 11, giving us about an hour. Okay. All right, we'll see you back then and we'll get an
This is a pivotal legal moment of the hearing. Even though the defendant denies the new evading arrest allegation, he has already admitted to several separate probation violations, including leaving the county without permission, failing to provide required income documentation, and falling behind on court-ordered fees. In probation proceedings, the court can often act based on proven supervision violations without first resolving every disputed criminal allegation. However, rather than immediately imposing the revocation, the judge decides to delay the final decision so the contested new case can be fully addressed and discovery issues can be resolved. That approach protects the fairness of the process while keeping accountability firmly on the table. What do you think? Should admitted probation violations alone justify revocation, or is the judge making the right call by waiting until all the evidence surrounding the new allegation can be heard? Let's return to the courtroom and see what happens next.
freely and voluntarily.
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for a 5-year deferred probation. There would not be a fine. There would be restitution that would be determined between now and when we come back for sentencing. Is that your understanding?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objecting state's one.
It's admitted. Is there any evidence that Mr. Eli is not competent?
No.
And I guess
I have the restitution
it's,
now.
is it the amount on the indictment of that check, 4,471?
No,
$55?
no, it is not, Judge.
It's different.
Yes.
Do y'all want to go?
Not by
ahead?
much. I mean, it's 8,132.88. And the only thing I would advise the court is that he has 3 pending, it looks like misdemeanors in Furio County that are not disposed of, to my knowledge. The defendant may know better than those.
Do you want to agree to that $8,000 amount, or y'all don't agree to that amount? Okay, so I'm going to states number 1 is admitted, and then I'm going to find, Mr. Eli, that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so we can get a pre-sentence report done, get that restitution amount figured out from their side. And then if there's some objection to that, if we need to have a small hearing, we can do so at that time. On your way out of the courtroom today, you need to stop and talk to probation. Is she sitting at that desk right over there?
Yes.
Okay, we'll see you back at sentencing.
Excuse me.
Yes, sir. Thank you.
Get a recess.
By the end of this courtroom session, 2 very different cases have reached 2 very different stopping points. In the probation matter, the judge accepts several admissions of probation violations but postpones the final revocation decision until a future hearing where the disputed new evading arrest allegation can also be addressed. In the second case, involving forgery of a financial instrument, the defendant pleads guilty, and the judge accepts the plea while ordering a pre-sentence investigation and delaying sentencing until restitution can be finalized. These decisions highlight how courts often balance accountability with procedural fairness, ensuring that important unresolved issues are fully examined before imposing final consequences. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.